All right, good morning, everybody. Welcome to the webinar of September. This month is barreling away fast and furious. So I hope that you are getting ready for all of your end of year and your general meetings and fun things. I know that our calendars are full with meeting attendances, which is fantastic. We are very excited about the topic that we have today, as excited as one can be, I suppose, relating to what actually has to happen to get to this point. But we are happy to be sharing the stage with our friends from Stratafin and DTB Attorneys. And welcoming for the first time, co-hosting a webinar is our very own Francoa. So Francoa will be introduced to you by Kyle, but he is a consultant at TVDM Consultants. And while he consults with us, he is also the director and founder of Willemse Attorneys, and his speciality is dealing with deceased estates or estates late. And we know that that is unfortunately one of the things that we all have to deal with at some point in our lives, either with our friends or our family. And I actually had the honor of meeting Francois, dealing with a very difficult time in my own life personally with the loss of my father, but he has dealt with it with the utmost of empathy and sympathy to the point that we've now become friends and he's part of the TVDM family. So we are very happy to have him co-host his first webinar with us today. The session is recorded and a copy of the recording will be made available on our website and social media as always. Kyle, over to you.
Thanks so much, Zelinda. Good morning, everyone. I hope you're all doing well. Just a couple marketing announcements before we start. As Zelinda said, this webinar will be recorded and published on our YouTube channel and website, as well as a copy of the recording will be sent to you all. Then if you haven't already, please do sign up to our newsletter. This way you can keep in touch with the TVDM Consultants team. And then lastly, our neighborhood live discussion will happen Friday, the 26th of September at 9 a.m. Please note that this feature is only available to paid for members, and if you would like to upgrade your current package, please pop me an email. I'll add my email and all these relevant links in the chat. And then just moving on to introducing today's speakers, Francoa Willemse. Francoa, an admitted attorney, an admitted and practicing attorney, grew up in Klerksdorp, Northwest Province, and attended the Northwest University, where he obtained his LLB and LLM qualifications with distinctions. During his studies, Francois assisted the Faculty of Law as a supplementary instructor and examiner for the law of evidence for third-year law students. Following his studies, Francois completed his articles of clerkship in civil litigation and road accident fund matters and established a deceased estates department, his area of specialty. Francois plays an active role at the Master's Office through the Pretoria Attorneys Association and is also a member of the Golden Key International Honor Society. With a passion for people combined with access to justice and transparency, Francois dealt with intricate deceased estate matters and gained valuable experience as a dedicated deceased estate administrator at leading law firms. Francois is also the director and founder of Willemse Attorneys, a law firm specializing in deceased estates administration, trusts, and the drafting of last wills and testaments. Then Mareliza Burger is a respected legal professional and director of DTB Attorneys, a specialized law firm focusing on the sectional title and community scheme living. With 6 years of experience in the industry, she is also known for a clear, practical approach and her ability to navigate complex legal issues with both precision and empathy. And then Willie has practiced as a property attorney for over 20 years. He was involved in the sectional title management for over 8 years, where he dealt with various municipal bills and interacted extensively with local municipalities. Willie started Stratafin in 2014 with the goal of assisting bodies corporate with their funding without catching them in a debt trap. Stratafin strives to be a fair and equitable money provider for the sectional title industry. Cool. Right on to Francois to kickstart the webinar.
Thank you so much for that introductions, Carl, and thank you for each and everyone who's joining the webinar today. Hopefully it will be an interactive session, so you're all welcome to ask some questions and hopefully we can answer them all. So I'll start right off. If you can see my screen, Carl, if you can just confirm if that's in order.
Yeah, all good.
Perfect. So today's discussion will be, sorry, let me just, in this webinar, we will cover the Wills Act 7 of 1953, the formalities of the wills, the appointment of the executor. More importantly, relating to this topic is the duties of the executors and the Intestate Succession Act. If you do not have a will, which I assume that everyone on this webinar does have, if you do not have one, you can reach out to us and we'll gladly assist you. We'll also touch on the roles of the Master's Office, and luckily it's National Wills Week, so we'll touch on that as well. And then I'll hand over to Willie and Mareliza to discuss sectional title schemes and levy collections in estate administration. I think from a personal point of view, that's a hot topic in community schemes, so stay tuned. So first of all, last wills and testaments are regulated by the Wills Act and the Intestate Succession Act. So the Wills Act, in brief, governs the drafting, execution, and the validity of wills in South Africa. It also provides the minimum requirements for a valid will to be accepted at the Master's Office and so forth. It also ensures mainly the testator's wishes to be respected and to carry out. In other words, a clear instruction is given to the executor of the estate to manage his affairs. It also addresses the revocation and amendments of wills. I'll talk a bit about that later on, especially with National Wills Week. You don't necessarily have to revoke your whole will and draft a new document, but you can also add to your existing will by way of codicil. So just briefly on the formalities, it must be in writing. I know that we are living in 2025 and with the introduction of AI, which basically everyone nowadays use, unfortunately, it's not possible to make a will by way of electronic means or video for that instance. So the Wills Act requires that a will must be originally signed, obviously printed, and then submitted to the Master's Office. More importantly, the will must be signed at the end of the will. When I draft a will personally, although not required, I would draft the will and have the testatrix or the testator sign on the bottom of each page. It's not a legal requirement to do so, and you may sign the will at the bottom of the will at the last page, along with two competent witnesses. But just for security, this is a personal thing. It's not required in terms of the Wills Act, but just to prevent someone from retyping a will and just adding pages. Obviously, we will need the testator to initial each page so that you can clearly see that that was the intention and wishes of the testator. Competent witnesses, that basically means that a person who signs as a witness to the will must be 14 years or older, and he must be competent to give evidence in court. So important to note that if you are a witness to a will, it doesn't necessarily mean that the witness confirms the contents of the will. It only means that the witness confirms the signature of the testator or testatrix. So just important to note that. And obviously, if you are an heir or beneficiary in terms of that will, you may not sign that will. We'll touch on it a bit later on when it comes to the invalidity of wills. The legal capacity of a will, I believe everyone should know that you must be 16 years or older and of sound mind to have a proper valid will drafted. Now, another aspect I quickly want to touch on is that, say you have a will, but you did not necessarily meet all the requirements or the formalities of the will. There's a gray area where you can approach the court to have this will be declared valid. That's called condonation, and it's done in terms of Section 2(3) of the Wills Act. I'm not going to give you guys the whole set out of the Wills Act. You are welcome to reach out to us, then we can discuss this in detail. And basically, for those of you who is interested in learning languages, you are in luck, because today I'm going to teach you two important Latin phrases, being dies sedet and dies venet. This is important for executors or agents, and it basically means dies sedet, the day has come, meaning that when the person passes away, all heirs nominated or listed in the last will and testament will have a hope to inherit something. I say hope with all respect, and the reason for that is the heirs can only hope to inherit something from the will because you have the estate administration process to follow. So the hope comes in that you do inherit the property, but that doesn't necessarily mean that you will definitely get the property. It might be there might be a cash shortfall in the estate, for example, where executors or the agent of the estate is compelled to sell some of the movable property, being vehicles, or lastly, and more drastically, the property. Dies venet comes in and basically mean the day comes. So if I can explain that in plain English, it basically means that when the executor submitted the L&D account to the master's office, it has been approved, it has lain open free from any objections in terms of the latest advertisements that you place, and the estate is now finalized. Then the heirs nominated in the will can enforce their right to claim the money or transfer of that property. So only at the end of the day will you receive your inheritance. But up until then, you only have a hope. Perfect. No questions so far.
There are one or two, Francoa. Would you like me to table them for you?
Yes, please.
Cool. All right. So the first one is from Marion. Please, will you mention how long it takes to appoint an executor these days? You can go for that.
Perfect. So to answer that question, and I'm going to sound like a proper lawyer, it depends. So it all depends on, and we'll touch on this at a later stage when we come to the duties of the executors. So that basically, it depends. So when you receive the documents, when you submit the documents, you have to ensure that everything is completed, fully, whether there are cooperation from the heirs in the estate, and but I'll touch on that at the later stage.
Perfect. The next question is from Sharon. Does a witness need to provide their details, for example, their name and contact details, such as their address or email address and ID numbers? Thank you to the husband for bringing me coffee. Francoa, do they have to provide details?
It is advisable, especially when there's a dispute regarding the legality of the will. And also, it's quite difficult to ascertain the details or the identity of the person just looking at the signature. So when we draft wills, for example, we have your witnesses signing at the bottom of each page, as well as the name and address and the relationship to the deceased. So it is advisable to have their details as well.
I know I always get very sad when somebody close to me asks me to sign their will, because that means that I'm not going to be benefiting from it. So, not a nice position to be in, but still has to be done, I suppose. And then the other question that came up is something I think I'll answer quickly. An executor can attend meetings and vote, but can he or she appoint a proxy? So yes, they can. The executor, correct me if I'm wrong, Francoa, or executrix, steps into the shoes of the deceased and then obviously will appoint a proxy to attend a meeting. Interestingly, Francois, have you ever attended any meetings, board meetings, or body corporate meetings on behalf of any of the estates that you administer?
Yes, I have. So it's quite interesting, and we'll get to that when we discuss the duties of the executor. And I think Willie can perhaps comment on this. The main reason why they would be outstanding levies is, for example, the body corporate is not informed of the passing of the owner, for example. But so Linda, yes, I've attended meetings, and you basically step into the shoes of that deceased person. Or the estate rather, will be liable to pay the levies, or at least arrange payment to keep them up to date.
Perfect. Philippe, would you like to step in here?
Yeah, Section 1 says that the executor, the executor is the owner for intents and purposes. So the Act specifically says that. So therefore, the executor then can do anything that the owner could do. I am currently the executor of an estate where I'm also the chairman of that body corporate in which the estate owns a property. And then Francois was right. That is one of the things that happen, is that the scheme is not aware that the person has passed away, and statements are not necessarily then given to the executor. So the executor might not be aware, but we also see in many instances where the estate is utilized as a mechanism not to pay levies, and that the estate keeps on running up the arrear levy, and that the property might be rented out, and income is then generated in a different entity. Mareliza and I will have a discussion a bit later on of examples in that regard. So yes, and then it does create a problem, and we'll discuss how legal action should then and what can be done, but not an easy task.
No, not at all.
Just to add, sorry, Willie, just to add on that, it also applies to tenants, I believe, and especially when you're renting, and there's a family in the section where you have to advise the body corporate, listen, this has happened, and but I don't want to explain too much. I'm sure that you'll get to that when I hand over to you.
Awesome. We do have a couple more questions, but I think let's go back to the presentation, and then I'll go back to the last question asked, and then we'll deal with some more questions afterwards.
Perfect. Moving on to the formalities of a valid will, I think we've discussed this in detail. So just to confirm again, it must be in writing, no video or electronic forms of a will be accepted, must be signed at the end by the testator or someone in their presence and direction. So just interestingly, I did a will a while back where of a blind person, and it was quite interesting to see and apply the rules in terms of the Act, whereby a commissioner of oaths basically reads out the will to the testator, and he confirms, and there's a lot of formalities regarding to that. So it is possible for a blind person, for example, to make a will. There's just a lot of extra admin that needs to be done. Two competent witnesses must be present and sign in the presence of the testator, and witnesses must be 14 years or older and competent to give evidence in court. The testator must have legal capacity and testamentary capacity. Just a note on that, when you draft a will, you have something called freedom of testation. That basically means that you can put anything in your will. I've had it before when we dealt with a will where the property and all investments, wherever situated, is actually bequeathed to a dog, a pet. And I know that Linda would do that.
Three of them.
But yeah, so that will, I mean, you can't enforce that. A pet cannot own property and so on. So that was initially declared to be invalid, and which forced us to follow the route of intestate succession. So I just wanted to mention that to you guys. I think it's quite interesting that the things you do see in practice.
Francois, can I ask a question? Would one be able to set up a trust that then looks after the pets?
But yeah, I think that's an offline discussion. I'm quite cautious advising.
I was just wondering for Zerlinda's sake.
Yeah, I know, right? I need to take it deeper. Okay, cool. I'll chat to you later.
So moving on to the appointment of the executor, and this is one question that we already had, and I'm going to stand still at this topic for quite some while. I'm just having a look at the time. So first of all, how can an executor be appointed? So there are two ways. The preferred method for me is in terms of a valid will, where a executor is nominated. You can't appoint an executor in your will, you can only nominate him. The discretion lies in the Master of the High Court to actually make the formal appointment of the nominated executor. In practice, I think it's good practice to have at least two executors nominated, not co-executors, just for the reason that there might be disputes between two executors, and which complicates and prolongs the finalization of the administration. So in practice, it would be wise to include a clause that should executor number one not be able or not willing to accept the nomination to be the executor, then you fall to the second clause, whereby you appoint another executor. Important rather to note that in your will, you must clearly state that this executor is exempt from furnishing security to the Masters of the High Court. So the second way in which an executor can be appointed is in terms of, we call it a nomination form that all family members basically signs to nominate someone to be appointed. That often happens when there's no will, and it can get quite messy, for the reason being that before we were able to lodge or rather report estates via the DOJ online system, the master insisted he wanted originally signed signatures and the nomination form. So you can think for yourself, it will be practically impossible to send the document overseas, for example, to have the original signature, then courier it back to South Africa for signature. And that all delays the appointment of the executor. So it is advisable to just have a proper will drawn up, appoint your executors, and do the appointment, or rather the reporting process, whereby the executor will be appointed. So the next bullet point, who can act as an executor of the estate? This is also one thing we see in practice, which can render the will to be invalid, or that portion of the will to be invalid. So there are, the general rule is all natural persons can act as the executor of the estate, but there are some disqualified persons or individuals that may not act as the executor of the estate. These persons are are minors, insane persons, or prodigals, unrehabilitated, insolvent, whereby the master actually has a discretion to make the appointment or not, provided that you provide him with reasons why he should appoint you. Interesting enough, when the master does decide to appoint a person who is unrehabilitated, he can request security to be furnished by the executor. Another person's disqualified from acting as the executor are companies, trusts, and partnerships. In practice, we often see that the will states that X company would be the executor. That's not correct. So a company, a trust, or partnership is represented by directors or trustees, for example. So you have to nominate the natural person, like the director or the trustee of that trust, to be appointed. The master itself cannot be appointed as the executor of the estate. I think that if that was possible, there's no saying when the estate will be finalized. I know that they have a lot of work to do and they have their own challenges. So I think that's primarily the reason why the master cannot be appointed. And the last person who is unable to act as the executor is an heir who signed as a witness to the will. So again, the master has a discretion to allow this or not, depending on the circumstances. You know, I've dealt with many cases where family members phoned me and said, listen, you know, dad is in a hospital, for example, and he needs an urgent will. So I had to go to the hospitals and draft the will there and have it signed. And there weren't any other witnesses available, for example. So the security by the executor, important to note that it's not, or rather, let me rephrase. Winding up a deceased estate can be costly, you know, and providing security to the master might be an unforeseen expense in the estate. The Act makes provision for certain individuals to be exempt from furnishing security to the master. The first one is in terms of your will, if that person is exempt from providing security to the master. But if you do not have a will, the master might insist on security be provided to him. Individuals that are exempt include close or not close family members, but family members, surviving spouses, and children. They will not be liable to furnish security to the master's office for his appointment. The other appointment that can be made is in the case where, let's say, for example, I'm the executor of my father's estate, but I don't want to be executor because I lack the practical knowledge and the processes relating to the administration. I may appoint an agent to act on my behalf. So this is basically the case where like I said, you don't have the necessary experience in the administration, then you just appoint an agent to do the estate on your behalf. And mostly in practice, we've seen that the son, for example, takes up the appointment as the executor and refers that to a legal firm. And I'm not just saying that this because I am an attorney and dealing with deceased estates, but it would be advisable to appoint an agent to act on your behalf. The reason for this is, like I mentioned, you know, lack of experience in administrating the estate, and this falls back to the Latin terms I've mentioned previously. So I just want to ask a question. So how many of you have heard it before where the family comes together and your sister mentions that, no, dad said, the car must go to me and so forth, so I took the car. That basically is why an agent is appointed, to foresee these kind of things from happening. You are only allowed to distribute the estate upon finalization of everything. So appointing an agent not only eliminates the emotional aspect involved in doing your father or your mother's estate, but it also gives you a sense of how can I put this? Trust in the agent who deals with estate to administer on your behalf. Important to note that you as the executor has a fiduciary duty to administer the estate and finalize in a perfect world within 6 months. The estate needs to be finalized. I know in practice that does not happen. There are many aspects involved that prolongs the administration process. I want to touch on the duties of the executor or the agent. Just remember that although the executor appoints an agent to administer the estate on his behalf, the executor at the end of the day remains liable for the completion. So dealing with debts in the estate, he has to ensure that F&B, for example, has been paid, the rates and taxes has been cleared, the property has been transferred, and he is the one who actually signs off the liquidation and distribution account to the master's office. So he cannot just appoint an agent and leave everything. Go sit and relax. He has to engage with the agent, and hopefully the agent provides adequate feedback to the executor on the process as well. So the process and the duties of the executor basically includes the consultations with family members, the reporting of the estate. That relates to the question that was previously asked about how long does it take. We are very fortunate to have the online system where we can report deceased estates now. And although the original will must still be submitted to the master's office for this appointment, the online system has brought down the timeline for issuing the letters of executorship to 3 to 4 months. Where in the past you wait about, I've heard the other day that people were waiting for 1 year for the letter to be issued, which is a huge problem because you cannot do anything without that letters of executorship. Other duties include that the executor or the agent must notify the creditors of the event, that this specific person has passed, and this relates to the body corporate as well, to notify them about the passing of the individual. He also has to deal with the noting of claims against the estate, and then he must also draft a liquidation and distribution account, which basically sets out which assets were in the name of the deceased, whether married in community of property, you will basically include it as one estate. And then he also has to place advertisements to notify the creditors of this event. I just want to see here if I've missed anything.
Shall we take 1 or 2 more questions, Francoa?
Yes, Elena, sure.
Just on the dispute between siblings example that you gave, here's a question. If a child rented from a parent when the parent passed away, can they now argue that since they will inherit the property in any event, can they stop paying rent? The way I understand it, business must continue. You've explained that until the estate is finalized.
Yeah, the short answer is no. Again, you must go back to the Latin terms we used, and you will only be you will still be held liable to pay, rates and taxes and rent for that matter, because you, according to law, is not the owner. The owner is the deceased person, so all rental income, according to law, should be paid into the estate-led bank account, not just for the executor's benefit, but for the benefit of all other heirs that might be in the estate. Because at the end of the day, those proceeds or rental income received will be distributed equally or to a specific person, depending on the will. If there's no will, you can sit with 7 or 8 children who's waiting on funds to be received. So the short answer is no. You must still continue. Hopefully, there's a proper lease agreement in place, which might avoid disputes as well.
Perfect. Are you going to be dealing with the cost issue of dealing with an estate or being an executor as well in the presentation? Because there's a question about what are the fees relating to executors' fees.
Yeah, so I don't want to jump off the wagon here.
Too
But
much
yes,
is my answer.
too little.
Too
I
little.
always joke in Afrikaans, tong in die kies, that we are only allowed to charge a maximum of 3.5% plus VAT on the net estate value. I think the issue of costs comes in that when you say 3.5% of the net estate value, and this should actually be explained in detail to clients, that does not include other administration costs. For example, the executor is entitled to a 3.5% fee. That's his fee for going to the master's office, placing the advertisements and doing his job, basically. That excludes payment of arrear levies, rates and taxes clearance certificates. You have to appoint, hopefully, an auditor who can code the estate with SARS as well. You have to get a tax clearance certificate, which the auditors do at a fee. You can't expect the executor to pay that out of his 3.5% plus VAT. The other thing that is rarely mentioned, and I don't want to confuse you guys, is with regards to the rental income, for example. That is income received after death. So basically, that will have an impact on the income tax that's payable after death of the deceased. And the executor, according to law, is entitled to 6% of that income received after death. That includes interest in the estate-led bank accounts, interest on investments. That's why we push to collect the monies as soon as possible. So hopefully that answers the question.
Awesome, thank you. I see Willie and Mareliza have also been answering questions on the chat. Thanks so much. I think we can move back to the presentation.
Perfect. So now we deal with what happens if you don't have a valid will. If you don't have a valid will, you are in trouble, to say the least. That prolongs the administration process quite a bit. And the question is, when will this be applicable in the event of no will or an invalid will? So how to determine the heirs of the estate, and then I'll briefly touch on the marital regime of the parties. So as I've stated before numerous times, the Intestate Succession Act will kick in when you do not have a valid will or no will at all. The heirs are determined in terms of the administration, and the dealing of the assets will basically be in terms of the Intestate Succession Act. So I know that where there's a will, there's a fight. Where there's no will, there's war. Basically, the reason for me saying that is, if you have a big family, the Intestate Succession Act will be followed to distribute the net value of the estate, which includes all the properties, all the movables, furniture, whatever it may be, to the surviving spouse. First of all, if you were married in community of property or out of community of property. But then you have to focus on a child share. So basically, if you were to pass away without a valid will, your estate will be distributed to your surviving spouse, but all your children as well in equal shares. So child share is basically, let's say for instance, you had a surviving spouse and you have 2 children and you have 1 million rand in your estate. So then you have to divide the 1 million by 3. Obviously, in terms of the Intestate Succession Act, a child share is 250,000 rand, which will basically go to the surviving spouse. The remainder will be divided equally between the heirs. So the problem comes in when you have illegitimate children out of wedlock and adopted children. That's a thing that comes up regularly. And that basically means that the estate will be distributed per stirpers, meaning it will go to the descendants, adopted children, and illegitimate children as well, or by way of representation. So if I can just explain this, I'm struggling to explain to you, but I'm going to use an example. The husband, they had 3 children, but the 3rd child passed away. But the 3rd child further left, let's say for argument's sake, 5 children. Now you have 1 million rand, which needs to go to the surviving spouse and the children of the deceased. That, by way of representation, we mean that the 3rd child who has now passed away, her share in that 1 million will be divided between 5 heirs. Whereas you have a will that directs the executor to make the bequest, it's just a lot easier. I think I've touched on the nomination forms as well that needs to be signed, difficulties in obtaining originally signed signatures and so on.
Francois,
And
we're running out of time. Would you mind terribly jumping to the very exciting part, which is the National Wills Week, and then we can hand over to Mareliza and Willie. A copy of your slides will be made available to everybody as well, and then we can just stay on a couple of minutes afterwards to deal with any further matters that you aren't able to touch on.
perfect.
We know people love the Master's Office, so we can skip that one for now and go through to the Wills Week. When is Wills Week and what you'll be doing?
So National Wills Week is basically aimed at raising awareness to have last wills and testaments reviewed or drafted. It's a free legal service offered for the drafting of a basic last will and testament in the week of September to ensure that your current will is valid. So we can review it for you. In the spirit of Women's Month, Willemse Attorneys actually inserted another week to adequately assist clients. So it will be from the 8th up until the 19th of September. You are welcome to contact us and we can assist you with a free basic last will and testament. So yeah, that's basically it. Hopefully I haven't scared you guys off, just to say that a will is very, very important.
I think you're going to rather chase people to do the right thing. Francois said, I think the last time we spoke, you had over 300 requests for consultations and free wills, which is really a great number. It's a lot of people getting their affairs in order. So I have shared your email address. So you're more than welcome to contact Francois. You'll obviously continue to work on that after the 2 weeks, provided you get the request during the 2 weeks.
That's correct. Yeah,
Perfect.
the instructions come throughout the Wills Week.
Awesome. And just those dates again, 8th to the 19th.
That's correct, yes.
Awesome. Cool. Thank you so much. Mareliza and Willie, I think we'll move over to you guys now. Sorry, Francois, for chasing you a little bit there.
No. Perfectly fine. Thank you, Linda.
I think Mareliza can go. She's the one that does the collection. So I think I'll jump
Yeah,
in
I
wherever.
think DTB gets involved in the complete opposite as the type of clients that Francoa gets. We normally get approached by the creditors, and being focused in the sectional title and the community schemes, we get approached by the schemes, and that will tell us we just realized these children have been living in this in the property, and they no one's paying the levies. We're sending out the levy statement, and then we realize we were informed eventually that the owner passed away. By that time, it's been years. The children has been living for free, and they definitely don't want to pay rent, and want to avoid reporting the estate because it's a free property. Just a quick side note: we've had an estate in Kreersdorp, where the children were living in the units. They were so comfortable. They were stealing the neighbor's laundry. They were making fires in the unit itself. It was such a mess. And the body corporate then eventually reached out and said, we need help. So it's not the family then that goes. They definitely didn't attend Wills Week, and we wanted the client will then ask us to assist in appointing an executor, or alternatively remove an executor. So there's a process that you can apply to remove an executor if they don't comply with their duties. For example, they're not finalizing the estate. Or if there's no executor appointed, then the body corporate can then elect to appoint someone their own, maybe the managing agent, or maybe a trustee, or even an attorney, which we do. Then we get appointed as the executor, and then we assist in finalizing the estate. Not an easy task. Like I said, the children or the family wants to avoid the liabilities, or they living comfortably, rent-free, stealing water out of the fire hose. Who needs electricity? It's a good life. Then we will try. We normally try and get their cooperation and get them to agree that we have to sell the property now. The banks have knocked, the municipality have knocked, nothing's happening. This is now the end of the joyride. Normally they won't give their consent, which puts us in a position where we then go to the master to tell them we need assistance. Please help us in selling this property. We need to finalize the estate. So it either then gets, generally it will go under the insolvent estate or the Insolvency Act. It will be finalized that way, unless there's still the property value and the levy, the creditors the debts have not exceeded the value of the assets of the estate. And then by a lot of follow-up and a lot of prayers, sometimes we get assistance from the master to allow us to sell the properties. But we've actually been advised, so the banks sit with a similar situation where because they've got the panels, a panel of attorneys. So the master told us that that's what the banks do. They will appoint one attorney on the one end, that will be the executor, and then the instruction goes to another attorney to then issue summons and proceeding with legal action against the executor, the same client, against the executor, just in a process to finalize the estate, because the masters are very hesitant to give the permission to sell the properties. So it's a very complex situation. I don't know, Willie, what can we add?
Okay, so firstly, in terms of the Estate Act, a creditor is always entitled to also nominate. So there is a sequence where somebody can nominate an executor where there is no executor. It is normally the spouse, children, and thereafter creditors. So in the event where a executor has not been nominated, like Mareliza has explained, for multiple years, the body corporate, as the creditor of that estate, can then approach the master for the appointment. So yes, the trustees can force that, because I saw that was a question. And then somebody gets appointed. Like Mareliza said, in many instances, a trustee, a attorney, or a staff member of the managing agent, and so forth. And then one can start working in finalizing that estate. And like Mareliza said, we had great difficulty in getting these estates finalized, where the creditor has appointed herself and me sat at the master's office on occasions where we agreed process with them, and then once we follow that process, they don't even want to follow the process. So I think at the last occasion that we were there, they informed us that the banks actually then sue the executor through another firm of attorneys, where they followed the same process, where the estate was not reported and there was a bond outstanding. So it is something that we are currently investigating to do, and to follow that process to get these estates finalized. But we also see that in some instances, properties were sold on an installment sale agreement. The property has never been transferred. And you now have somebody that is the owner of the property because they have bought that property on installment sale. They don't pay levies because the levy still accrues against the estate. So in essence, they have shifted the estate or the property away from the person that is liable for the payment of levies. We're currently dealing with an estate that had 24 properties in it, where they've done that. We are now at the process where we're executing on those properties. So the people that have bought those properties on installment sale agreement will then lose those properties at the end of the day. Definitely a problem in the industry. So trustees and managing agents should be aware if somebody passes away, they should act as soon as possible, because at the end of the day, we have seen estates that have not been wound up for more than 15, 20 years in some instances. And with prescription that we now think can run under certain circumstances, one must be very careful that the body corporate will not lose all those levies, and that trustees then will be held accountable because they haven't acted in accordance with their fiduciary duty to move forward to have those estates wound up. I think from an estate point of view, just be aware if somebody passes away, start action as soon as possible.
I've also had a couple of queries from clients where they'll reach out to say that the trustees will phone and say, we know this person passed away. And once we would do a consumer trace and try and find the date of the passing or to verify so that we can follow that route, then we never found that his passing has been reported. It was once, for example, that I think he didn't have any family. They said they just saw they took him out, but we never got a death certificate. Another one where he left the country and he passed away in another country, but again we didn't know anything, and it wasn't reported in South Africa. The body corporates need the levies and they must proceed. So then we've proceeded against legal action because we don't have any confirmation that this person is actually passed away. So that also happens. There's so many scenarios that takes place with deceased estates.
And where you are aware, like Mareliza said, because we've also had matters where people have passed away and then we have proof that the person has passed away, but not necessarily in South Africa, then you have to bring an application for judicial citation, substituted service to serve in other countries on an executor there, so that one can proceed with legal action in South Africa. So the body corporate has to act as soon as possible. As soon as they are aware, they need to start acting. Obviously, when you appoint an executor, you will first go to the heirs or the children or the spouses. You always start there. That is the start. But where they haven't done so in many, many years, one sees normally that they don't want to appoint somebody because they are receiving a benefit out of the unit. The bond and the levies exceed value in many instances, so they will just continue staying there, not paying, and the body corporate will eventually lose, because at the end of the day, one can never recover more than what the value of that property is. So it's important to proceed with legal action as soon as possible.
Yeah. And just on our last question, I see here, Julie asked, we've had scenarios where we then approach the master to say, okay, we want to appoint on behalf of a creditor, and the master will then ask for they require that we do traces and we give them the contact details of the heirs. The master actually reaches out to these people and try and set an appointment. They even advertise it in the GPW and the government printing, the government gazette, to try and get the family to come to the master's office so that they can sit around the table and try and finalize it through the heirs. But yeah, unfortunately, not an easy task.
It doesn't sound like it. I saw someone posted that they weren't aware that a body corporate could actually go through this process. I wasn't either. I found it very interesting. Could you perhaps just confirm from your side how many of these matters that you've dealt with and what are the common challenges that come up? Is it something that the trustees aren't willing to do? Is it something that gets fought? Like, what are your challenges that you come upon in these instances?
We currently have about 80, Mareliza, if I'm not correct.
Yeah, so
80
Stratafin,
estates.
you guys have been approached quite often for purchasing the debt, because then the body corporate, they don't know what to do anymore. And we have 80 units, and the main issue is the consent from the family. Willie, what do you think?
Correct.
Wow, that's hectic. I'm just adding your contact details to the chat here. I can imagine, I mean, Willie, you're always in contact with people in the industry. You would be open to engaging with the body corporate to see their chances of success in this type of application before taking them on formally?
Definitely so, yes.
Perfect, 100%. But at least I'm going to add your details and Willie, yours as well. I see one other question popped in from Jennifer. I manage a body corporate where one of the units is in the name of an estate late for the last 12 years. Can this really go on indefinitely? I think, Willie, you mentioned 20, 30 years, eh?
Yeah, we've seen stuff where the guy passed away in 1992, if I remember correctly. And I can mention it's a estate late Novik, I think. Passed away in 1992, and that debt was eventually then sold to Stratafin, and we proceeded with legal action in that matter.
Sure. Yeah, and like what Willie said, like what Francoa mentioned, it's the master. They're quite overloaded with work, and I honestly don't think they are going to take the extra step in finalizing an estate. So once it's reported, even if there's an executor appointed, it can stay there in the master's office for quite some time.
I can imagine. So I know I think Francoa goes through to the Johannesburg Master's Office once a week and then to the Pretoria Master's Office once a week. And he says that he has to be there before 7 o'clock in the morning. And sometimes he gets seen early, sometimes he doesn't. But it sounds like there's a lot of hurry up and wait. And he was summoned to the Master's Office the other day. They told him on a Friday afternoon that thou shalt appear before the Master on Monday morning. I can't imagine that he had a very nice weekend. But Francoa, jy mag nie meer met my kla nie as ek te lank vat, né? Francoa was so serious with me that he even forced me to acquire a printer because he was cross that I was like, I don't print anything, Francoa. And he's like, yeah, but you need to print this in original and you have to have it commissioned. So he's been on my case. Luckily, I didn't take 20 or 30 years, so you can't complain anymore. Francoa, any comments from your side?
Not really. I think we've covered everything, especially for National Wills Week, and hopefully, so some of you guys will go and review your last will and testaments. And just one last thing from my side is with regards to policies, which may actually assist in paying levies accounts in body corporate. Is when you draft your last will and testament, we've had it before, where it was stated that policy X must go to Sir Linda, for example. But just know that you should also update the nomination and beneficiary form at the institutions as well.
But a lot to remember, everybody. I think we've got 1 or 2 minutes. I'll open it up for the floor. Francoa, if you can just stop sharing on your side that we can see everybody. If anybody has got any questions that they'd like to verbalize, they're more than welcome to do so. We've got a minute or two. Otherwise, thank you so much for joining us. Willie, Mareliza, baie dankie. Always very informative to listen to you guys. Remember that what Stratafin and DTB do, very, very important to engage with them in your body corporate, not only when levies are getting you down, but for general property advice as well. Willie has been in the game for many, many years, crazy knowledgeable, and we refer a lot of our interesting conveyancing matters to Willie as well, because that's his background too. And Willie and Mareliza work hand in hand on these matters. Anybody have any questions from the floor? Now's your time. You're more than welcome to raise your hand or put your camera on, unmute yourself. Yes, the recording is going to be shared. It'll be on our website, as well as the slides will be shared as well. And the contact details of Francoa's firm, Stratafin and DTB. Also remember to sign up for Stratafin's free trustee training. If you haven't yet done so, super, super comprehensive information there. Other than that, thank you so much. Thank you, Mareliza. Thank you, Willie. Thank you, Francoa. Thank you to all of you that attended. It was a great session.
Thanks, guys.
All attended. Until next time, keep well. And please do contact us if you've got any questions. If you'd like to chat to Francoa, Mareliza, or Willie, I have shared their details. You're more than welcome to reach out to us as well if you've missed it. Cool. Thank you so much, everyone. Have a good week.
Thank you, guys.
Good week further. Good weekend coming up. Keep well. Bye-bye.